Welcome back to Legally Speaking with the McLario Firm. Well, people often get nervous when they hear the word probate, but is it such a bad thing?
Joining us now is attorney Maxx Forti with the McLario Firm to chat all about things probate. Good to have you back.
Good morning.
Yeah.
Thanks for having me.
It's so funny because nobody wants to talk about this stuff, but it's important if you don't know what these things are and what they could mean for you when they come to fruition. So what is probate? A lot of people don't understand it.
In the simplest terms, probate is just a court-run process to handle someone's estate.
Got it. So after you've passed.
Yep, correct.
Got it.
How do you know if you need probate?
Well, there's a lot to it, but the simplest way is if someone passes and they don't have beneficiary designations on their assets, and the asset total is over $50,000, then you'll probably need probate.
Yeah.
Okay. So are there different kinds of probate proceedings?
Yes, there's a couple. The main two are actually informal or formal. Informal, very straightforward. Generally, someone has a will, they name the personal representative, they name their beneficiaries, and you provide that to the court, and you kind of go off of that. With that, all of the beneficiaries, or interested persons, as the probate court refers to them as, would sign waivers essentially saying that they nominate the personal representative. And everything goes through and just a normal probate process from there. The other type is formal, which means that along the way there was an issue. Someone didn't want to sign a waiver, or someone's contesting the will or other aspects of the probate.
Okay. Yeah, the contesting parts where it seems like it's tricky. Can someone open a probate without an attorney?
Yes, you can. You can open a probate.
Probably not advisable.
No. As they refer to it as pro se, you can certainly do that. The main issue with that is essentially the courts aren't allowed to give legal advice. So if you have questions and something happens that you don't know what to do and you've never dealt with it before, you really have
confusing.
It gets really confusing, and
could be costly for you if there's something that you could be entitled to.
Exactly. And then you have to go and try to find an attorney at that point because you're in the middle of it, and it gets a little bit more confusing, takes a little bit longer, and obviously that's the main part that everybody is concerned about with probate is how long does it take. It's the main question I get asked all the time.
How long does it take?
Well,
Long time.
It's a broad question in sense. It depends on what the assets are,
and how many people can
how many people, if there's any creditors or anything, what assets are involved, houses, cars, all the above. I'd like to tell clients that it depends.
Yeah.
But rough estimate at minimum, 7-8 months before you get. That's just the ability to receive your distribution as a beneficiary.
Interesting. So how do you open a probate?
Yeah, so there's a lot of forms, and it's just filling out applications, certain forms that ask about heirship, certain forms like I talked about with the waiver to get the interested persons to sign off on it, and then some other forms as well that are meant for the court to approve, as well as a notice to creditors, because that is a normal part of probate, which would be to notify any potential creditors of the estate.
We're running out of time, but the one thing I think people always want to know is how can I avoid probate?
Yes.
And the thing is, the person with the assets is the one who really has to make sure their loved ones can avoid probate. And the way you do that is you make those distinctions. You designate the people you want to inherit your assets.
Yes, the simplest way is beneficiary designations on everything, and obviously wills only do so much. Trusts are great. It's just an easier way to make beneficiary designations. But those are the main things that you should do always. Just make sure that it's going to somebody and you're not leaving it to no one.
So if somebody comes to meet with you, is there anything they need to bring?
Yes, generally I would really appreciate if they would bring death certificates, a list of the assets, if there's a house involved, the deed. If you don't have the deed, a property tax return, anything like that. And then also the information for any of the interested persons that you would believe are involved. Obviously, if there's a will, please bring that as well.
That'd be helpful too.
Even if there's a trust, sometimes you have to go through probate for certain things, and there's a trust as well. Bring any estate planning documents that you may know of or have seen, and we'll go from there.
That's why people put it off. It's such a pain.
It's a lot of stuff.
Such a pain.
It is. Yep.
It's good to see you, Max.
Yeah, thanks for having me on,
The
guys.
thing is, you need somebody you can trust. So call the McLario Firm today. You can set up a free consultation. Give them a call. It's 262-251-4210. They can go over what you need or what you need to do. For more information on all their areas of practice, you can visit them online at McLario.com.